to Atlantic Ocean, upon me hills, to country, to educate, elevate, and promote. Yeah, focus on Liberia, for Liberia, Liberia, for Liberia, yeah, 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 yeah. From Monday to Sunday. From Monday to Sunday, it's focused on Liberia. Talk about home affairs, in diaspora, current affairs, reliable information. Education, entertainment, business, sports, advertisement, articulation. Focus on Liberia. Focus on Liberia. Focus on Liberia. From Monday to Sunday.
At Focus on Liberia, we discuss everything Liberia, from education to politics, arts and culture, entertainment, agriculture, history, religion, family, and technology. Focus on Liberia uncovers and showcases the best of Liberia and shows the world the truth about Liberia. We educate, elevate, and promote all things Liberia. We conduct interviews, panel discussions, debates, and more. Tune in to Focus on Liberia on Facebook and YouTube and be a part of the stories that make up the news.
This is Focus on Liberia, and I am Tenured.
And I am Anthony Sid. A pleasant welcome to Focus on Liberia. Of course, you heard it there. We are about educating, elevating, and promoting all things Liberia. We are here today to elevate the discussion on the rule of law. The Supreme Court of Liberia has given rulings that others view as serious political blow to the government that has been purporting as a government of rule of law. Joseph Yimambwaka received a stinking blow, politically speaking, from the Supreme Court of Liberia in matters concerning tenure position. We are all aware positions that are tenure today in Liberia were created by the Unity Party's government, in which Joseph Yimambwaka was the second lieutenant. And here we are, Comrade Bwaka, based on advice from a legal man, is saying, no, we can appoint as we want. Where are you coming from with this tenure thing? What is not done legally, the legal minds will tell us it's not done at all. Well, seated and ready to participate in the discussion is Anthony Wonder Conyan Freeman. It's good to have you. Welcome.
Thank you very much. Happy to be here.
We also have Mr. Jerome Gidman. Mr. Jerome Gidman is the host of Focus on Liberia, opinionated political show on point, relentless. He's uncompromising. He comes with a Sacramorian cup that he drinks from politically. Joining us from the city of what? What is your city again?
Fort Pierce, Florida.
Fort Pierce, Florida. I was there and he took me to that little beach there. It's good to have you. How you doing, sir?
Thank you very much. I'm relaxed, as you can see, because I'm on my I told you so mission. Thank you very much for having me.
All right. Jim Victor Nambwe is a veteran from all the way, the hill days of the progressive movement, from the United People's Party, and now affiliating with, it's not a different CPP, but he is a member of the the Alternative National Congress. He is focused on liberal political analyst. Mr. Namu, it's good to have you. How you doing, brother?
Mr. C, it's good to be here. I think my beach is bigger than the beach that Jerome is boasting of. Um, here in South Jersey, we have a very big bulwark, but I'm glad to be here. I am still a member of the UPP. I just kind of went to lend a helping hand to the CPP.
Oh, okay.
But I'm back on base. I'm glad to be here.
Well, we're just hoping. Dennis said he believes that the progressive will resurrect. I hope they will resurrect with you. You guys have been in the vanguard. Jimmy Eastman joins us from the nation's capital, Washington, D.C. Jimmy, how you doing? How's family?
Family is good, and it's a beautiful day in the nation's capital. It's a privilege to be here with these distinguished gentlemen. But my man, you near Coney Island?
No, man, come down to New York.
No, I'm in Atlantic City, South Jersey.
Atlantic City. Okay.
Yeah.
So I'm looking forward to an interesting discussion, Anthony. It will be good.
Full disclosure, Jimmy Eastman is a team member here at Focus on Liberia. Pastor S.T. Salif is a sustainable development coach, but don't think he's not political. He knows how to be apolitical, but he also knows how to play politics. It's good to have you, brother. How you doing?
Thank you, Mr. Sia, and thank you to all the other wonderful panelists. I'm looking towards a very great show tonight, and we have a cream of great minds here tonight, and I can hope that the show will be interesting tonight.
I certainly hope too. To all Liberians following us now and those who will watch later, we urge you to be part of the discussion. And for those watching now, we want you to share the broadcast with somebody in your contact. Facebook has not been very friendly to us. Facebook is suppressing also until you share. We may not have many people watching the broadcast. The rule of law, we are told, is like the fulcrum of any democratic nation. We must follow our rules, for when we do, we respect everybody, and then the nation flows. And so a government now, headed by Joseph Yemambwaka, was elected on that mantra, the rule of law. Well, but the Supreme Court is telling this government, you were in error for appointing individuals to turning position by dismissing others who were still on their turning position. So these brilliant minds are here for us to talk about this. Gentlemen, let's start with your reaction, given that this new government ran on the rule of law. And Jerome, you are not a friend of this government. Sometimes you try to be balanced. Some people accuse you of being a Spainer. What is your reaction when you saw this ruling? Were you shocked? Something you expected? What's your reaction?
Honestly, I wasn't shocked. Like I say, I'm on my I told you so tour. So I'm traveling around the corner, going on every website, every talk show to just let them know, just rubbing it in your faces that I told you so. Because 2006, we in the CDC, we were disheartened when we lost the elections. But as patriotic Liberians, we all flooded to Liberia to welcome the new government, new stands, a new group of folks, and they needed the time to gel. They had something called the A-team. They said the brightest of the brightest among us. And when you look at the resume and the personality that Ellen brought along, you had no other choice but to agree that this is the team that will take us through the promised land. And then when they were putting these legislation, the code together, everybody said, well, they were well thought of. One of which is the tenure concept. And she educated us as to why tenureship is very important. It was to give autonomy to agencies that may stagger with the government term. For instance, if I'm coming in for 4 years and someone has a 6-year tenure, they do not have to cater to me, because when they lead, there will always be continuity. And that sounds very good. So for Joseph Boyka, who was the co-pilot of these programs, to come back later on and say these were all scams, it tells me that either he was selling rotten apples to the folks and people listen. So I wasn't shocked that the Supreme Court swung the pendulum in the middle that says, listen, go back to the rule of law. So I wasn't surprised. I expected this.
Thank you. Anthony Freeman, continuing my friend, Nina, I like to call you. You spoke on the relentlessly during that period when the president was bent on appointing individuals to the tenure position, and your position has been clear. What is the interpretation legally now, or you are our legal man here, of the Supreme Court ruling for the layman?
Well, the Supreme Court reinforced some of what we've said, that there is no greater article in the Constitution in relation to other articles, because like those who were championing this were citing Article 56. And the Supreme Court sort of equated 56 to 89 and said, you know, just as you have 56, there is 89 that gives the legislature the right, you know, to pass these laws. And outside of showing that there is some fault on the part of these officials, you can move them while that law is in existence, and that law is constitutional. So I don't think it's a bad news for them if they are interested in the rule of law. And we should all welcome the ruling that it provided some clarity, even though it was totally unnecessary. I said it because in 2018, there was the Martin Sele case in which the Supreme Court in very clear terms stated that the tenure laws were constitutional. 2020, Asa Jackson went to court, and the Supreme Court again reiterated that the tenure law was constitutional, even though that was not the crux, but in passing, they made that statement. Then the Clark-Martin case in 2023, I think, or this 2024, Clark-Martin went to court, and the Supreme Court made it clear that this law is constitutional. So after back-to-back legal opinion where the Supreme Court made it clear that the law is constitutional, to see Mr. Boyka with his 50 years of experience still going back to the court to seek clarity on an issue that the court has made clear on 3 different occasions, it didn't make sense to me. And I said that they were going to lose. There was just no other way they were going to lose. And that's what has happened. It's embarrassing for them, I guess. In the spirit of the rule of law, we should all welcome it.
Before I can bring the next person in, Councillor Jewer is focused on Liberia legal analyst, and he has throughout the debate maintained his disagreement with Anthony Freeman. And he writes, for every basic and good reason, I strongly believe that the Supreme Court is legally and deeply wrong. The power of the President of Liberia to nominate and appoint Liberians in his government is highly and constitutionally restricted. The appointment power of the President of Liberia cannot and should never be restricted by any court of Liberia to include the Supreme Court of Liberia. Our Supreme Court is established to construct and even-handedly apply the laws of Liberia. Our Supreme Court must stay away from making laws, interpret, and apply the laws. I am not surprised that I am not disappointed by the young-led Supreme Court bench. I want to be honest. 4 out of the 5 justices on our Supreme Court bench were nominated and appointed by President George Weah and his CDC-led government. And then what? What more do we or should you expect from this court? Not much. The young-led government is much more political in its actions and legal. In action than legal. I am deeply disappointed. That is Councillor Frederick A.B. Jewell, focus on liberal political analyst. Someone might think that Jewell is sounding political, but he says he's speaking from his legal opinion here. And Konyine, you're the lawyer here, then you should argue with the lawyer. Don't you think Councillor Jewell has a point here? Because he's now looking at the Supreme Court from political lens, though.
Yeah, that's how it sounds like to me. It sounds like because we lawyer, we live and die by precedents. So in 2018, the Supreme Court set a precedent in the Martin Sele case and said tenure is constitutional. Then Asa Jackson went to court, tenure is constitutional. Then Clark Martin went to court, tenure is constitutional. So there was no other option except the court was going to record those prior decisions. But it's very difficult. Like I said, since 1847, there's only one instance of the court recalling a prior decision. One from 1847. So there was, in all honesty, no likelihood that the Supreme Court was going to recall other prior decision in which they said that it was constitutional. What happened was that when these people are elected, they develop a certain level of better than thou attitude. And so they're no longer willing to listen to the voice of reason. They are no longer interested in listening to the voice of logic. They tend to believe that they are somewhere in the stratosphere, somewhere above mankind, but below God. And that whatever they do is correct. Now the Supreme Court has cut them back to earth and told them that you are not running a monarchy. You are running a republic where there are three separate co-equal branches of government. If you follow the council argument that there should be no limit on the presidential power, we may as well put a crown on your head and make him a king. But we don't have king in Liberia. We have a president subject to the rule of law, subject to the balancing act of the national legislature, and subject to the balancing act of the Supreme Court. And so that is why the Supreme Court has cut them back to size. I hope they take it as a cue and begin to operate, because this is the second legal defeat. You will recall that they also suffered legal defeat in the not code of conduct, but the asset declaration issue. So yeah, so that's my take on it. I think the councilor was being more political than legal because the precedent had been set from 2018. So there was no way the Supreme Court was going to recall prior decisions.
Thank you. J. Victor Namwe, the councilor is raising two arguments, one on legal ground, and now he's looking at it from political lens. Well, 4 out of the 4 members of the Supreme Court bench were appointed by the previous government, he argues. So more than likely, they will go against those individuals because they were appointed by CDC. So they want to maintain the status quo because it's like we are appointed them, so they got to. Is there any reason to believe that? And then he also talked about the presidential power should not be restricted to a point. What's your take?
Well, I mean, I respect Councillor Joel, a lot, but I'm not sure. I mean, like Councillor Freeman just indicated, that there are instances here prior to, the coming into office of this government where the Supreme Court has affirmed the constitutionality of tenure, and so. I don't see this as an attempt to hand the UP government a defeat simply on political grounds. I think the law is very clear, and a number of us here, I'm not a lawyer, but a number of us here have been saying that we thought the government was going to lose because there were just several pieces of this move that were lacking. No due process, no ombudsman. What is the basis on which you're removing these people? And so we already said they were going to lose. And so to say politics is a part of this, I doubt it, because the law is very clear. The law is very clear. The president, I don't understand the argument that the president's appointed power should be unrestricted. The president is not the boss of the executive, of the judiciary. He's certainly not the boss of the legislature. they're equal. So he cannot, exercise powers over the legislature, just like the councilor said. Though he has 56, that gives him the right, but there's also 89, which gives the legislature the right to enact laws. And the tenure, it's constitutional. This is a process that was started when this president was vice president. So he should be very, very familiar with this process. And I'm just kind of confused that he dug his heels in and and dragged this thing out. And now this today. So I don't think this is a political move. If anything, I think this is more apolitical. And I think for once we should be proud of the Supreme Court for coming down the way they did. I think they applied the law as even those of us, the laymen, expected the law to be applied. The people who are tenure, you have to remove them for cause, give them due process. None of this was done. This is tantamount to a hostile takeover, and just like Professor Clement indicated, these things can be arranged, right? These are your co-equals. You can cite them to a meeting, and try to smooth things over. I don't think the president ever did this to the legislature. I'm not sure if they ever went there to provide justification, maybe even the Supreme Court. I don't know. But my take on this is I don't think this was a political move on the part of the Supreme Court at all. I think they just applied the law.
Mr. Sherry Salif, sorry, when the tenure positions, these are positions actually created by an out of national legislature, the office of the president or the presidency have to affix a signature for these to become actually laws. For example, the one creating EPA, the act was created by national legislature. For it to become law, the president needed to sign, and that happened. And President Bouaka at the time was around. So the signature of the presidency contributed to making this law. So for the president now to go by appointing individuals when people are still turning at other places and removing them, was it not constitutional and also unconstitutional on his part?
Thank you for having me. I think, listen, we got to be very honest, fair, and equitable here. What the JMB administration did was nothing short of a mere political missteps and overreach. There was no reason they should have done what they did, because Mr. Bouaka, President Bouaka, was vice president, and as vice president, he was head of the Senate. So he was in the know of what happened. His administration at the time created the act that brought in a paternal position. So to then come back after 6 years and say, oh, no, we got to go against that, I am suspicious of the counselor. I mean, he sounds more suspect to me and more political than the Supreme Court, because if the ruling had gone the other way, then it would have been more chaotic, more concerning. I don't see the Supreme Court decision being anything political. This is exactly what's supposed to be, because what was the reason? I would have said Mr. Bouaka, President Bouaka, should fire whoever advised him to make that decision. But the only reason I can say that is that means he will be firing himself. He will have to fire himself because he was part of the creation of this tenure position. So as vice president, then to come back as president and say, oh, no, I don't care about that, that is deeply concerning. And what the counselor is saying is very troublesome. That means he's saying we don't need the judicial branch of government. The president should have absolute power. Then we don't need the judicial government branch to make laws, to do anything. The president can just sit and make pronouncement and just wave his magic wand and things happen. And that is deeply concerning that a counselor will propose any such thing. He's proposing that the president should have absolute power, absolute authority to do these things. Then we don't need a democracy. Any president can just come and undo anything. And, it is highly concerning. I mean, I will agree with the counselor on some other things, but on this point, I think he dropped the ball on this one.
Jimmy Eastman, you are in the nation's capital. In the United States, the balance of the court, based on Republican and Democratic views and perspective, is a crucial political debate because most of the judges on the court, it has been perceived they tend to make decision based on, where they come from. And so now Councillor Jewa is saying, well, the decision came down this way from this bench because most of the members were appointed by President Weah. Is there any reason to think that is true? Do you, think Councillor Jewa has a point here or not?
Thank you. I think I only did about 3 courses in law when I was writing my MBA. And I can tell you those law courses were the most difficult of all courses I've taken. I've done some high science courses, but the reason why the law courses were so challenging, lawyers don't argue from one angle. They look at things from several angles and they can argue from different perspectives. So if we look at this, anyone who serves the executive serves at the will and pleasure of the president. So if you are serving in an executive role by right, the president, you serve at the will and pleasure of the president, that means you can be removed. Now, they've gone ahead and created these tenured position in the executive. Now, an ordinary tenured position will be a judge. Now, the president cannot remove any judge. He cannot remove any Supreme Court judge. He doesn't have the power to do that. Okay? But what they have done by creating this tenured position within the executive, you bring together conflicting laws. Okay? And that is the reason for the conflict. So the Senate, well, the president was signatory to it. The Senate and the legislature, they decided they would do that, but they should have known they would be invoking a conflict when officials of the executive supposed to serve at the will of president, will and pleasure of the president. So they should have known that when they were going to invoke this conflict they're dealing with today. So by right, given the precedents that the Supreme Court had always ruled that somebody in serving as a tenure is legal because they signed it into law. So by precedent, the Supreme Court is right. They are legally there. And to remove them, you will have to follow the due course. And that is, they have to have done something impeachable or removed that will warrant their removal. But this whole thing was concocted by the very executive and legislative branch all by itself. They should have known. We have a lot of things going on in our country that is in direct conflict with even our Constitution. Our Constitution put people above the law. That you can't do that. Nothing's supposed to be above the Constitution. We have done a whole lot of mess with our laws, and until we straighten these things out, we'll always have these issues, and it will be always very difficult to, even the citizenship is arguable, but we have done this to ourselves. So we need to sit back and really consider reconstituting the Constitution, because there are too many conflicts, too many issues to resolve, and it's one day it's going to be a problem. So the sooner we do it, the better.
Thank you,
Anthony. I want to provide some feedback to what Jimmy said.
Okay, just a minute.
Okay.
Go ahead.
Oh, you want me? Okay, fine. So, Jimmy, there is a technical reason why the tenure position came into being, but there is a legal reason why. Most time we know that the executive implements the law, the legislature makes the law, and the judiciary interprets the law. But some agencies have 2 or 3 aspects of that power. And because when they exercise some level of judicial power, they need independence. So that is how, as the international body move towards good governance, some institutions have been insulated from political pressure by. So what you have are generally regulatory bodies that implement and at the same time they adjudicate. I will give you an example. Say the Independent Information Commission. They implement the laws of the Freedom of Information Law. But if you file a petition to them, they will sit as an adjudicatory body judging cases and deciding the fate. So when they are exercising that kind of power, they are both operating by the executive implementing, and then they are adjudicating. And also too, because of what they are governing, they may write a regulation governing how they operate. So you can have an agency that may be executed by structure, but they have powers of all 3 branches. And so it is on that legal basis that some institutions have been granted independence by way of tenure. It's not only that, for example, LTA.
Yeah, I'm
They
about to
implement the telecommunication law. If there is conflict and you file a petition there, they're going to sit in a forum. The same thing happened to the PPCC. So there were several of the agencies that exercise both adjudicatory, legislative, and executive power. And that is where the independence is coming in. So I just wanted to provide that clarification.
Very good.
And to just to second that, I mean, I also am not a lawyer. I did just 1 semester law course during my degree program, but basically the laws are usually interpreted on intent. So what was the intent for creating tenure position? If that intent was for the good of the country, then what was the intent of what is the intent of the JMB-led administration to decide to dismiss these people and appoint new people to it? So we have to look at intent. So there is no moral justification for what JMB and his administration did. It was an overreach, it was a misstep, and that's why they got embarrassed and disgraced. And he should advise himself properly. We cannot keep overstepping laws, or else why should we make the law if we're going to overstep it? Now let's flip the script. If this tenure position was created under the JMB administration as it was done under the early administration, let's assume if they had tenure people in position when the CDC took over and decided to dismiss those CDC people, would they be still tolling the same line they're doing today? Is ludicrous. You know, we can't be making law and dismissing it at will just when it suits us. It's troublesome.
Anthony James L. Johnson, Jameson just joined us. Welcome, Anthony Jensen. The law that created these turning positions spelled out costs for removal. Our new government now is the rule of law government. So one would think that they might have costs for removing these tenure individuals and appointing other individuals to their position. You think they have any costs? I don't think they acted with no cost yet. I don't want to believe so. What you know?
You're muted.
Anthony Johnson, unmute yourself and answer the question.
Okay. This is what I think Joseph Boyka is right. He has the constitutional authority to appoint and remove anyone that is being placed into government. Why am I saying that? The Constitution of Liberia, Article 56, A says all cabinet ministers, or not some, all cabinet ministers, deputies and assistant cabinet ministers, ambassadors, ministers and consuls, superintendents of counties, and other government officials, both military and civilian, appointed by the president pursuant to the Constitution, shall hold their offices at the pleasure of the president. Now, let me not B says there shall be elections of paramount clan and town chiefs by the blah blah blah. I'm going to go to the second phrase there. The legislature, they may be re-elected. No, the legislature shall enact laws to provide for the qualification. Okay, that's not what I'm looking for.
That's what we call that re-litigating. You re-litigating what has been litigated.
Listen to me now. You've been talking. I've been out. I don't have much time here. I just came.
Yeah, go ahead.
Right? The president shall have the power to conduct the foreign affairs of the country, right? So my concern, or what I think Joseph Barker is right, is because this is the voice of the framers of the Constitution. Those who wrote the Constitution, both the 1847 and the 1986 Constitution, is clearly stated that the president has the free will to appoint anybody and to remove anybody. Now, if the legislature created any law creating a tenure position, that law conflicts with the Constitution. I think all of you put this is a common language here, right?
Yeah.
The textual meaning of the provision of the law says all cabinet ministers, all officials of government shall work at the will and pleasure of the president. It's not because we don't have to like Joseph Barker, but any president, if James Johnson become president tomorrow, you can trust me, nobody in Liberia, even the Supreme Court, will not stop me from appointing and nominating anybody and dismissing anybody, because that's the law. Now, let me admit here, I haven't read the Supreme Court latest opinion that came down, right? But I have before me the organic law of the country that supersedes the voice of the Supreme Court. So the Supreme Court interpretation, yes, as a lawyer, I have all right. I've been trained to disagree with Supreme Court opinions. As much as we respect them, they have the right to say what they have said. But the reason why we went to law school was because we read cases and make analysis of those cases. Can the Supreme Court decision supersede Article 56A of the Constitution of Liberia? No, it cannot. Is it not clear here? The textual meaning here, there's no ambiguity in Article 56A.
Anthony Jensen?
Anthony Jensen, sorry to interrupt.
Hold on, Pastor Sari.
Interpret Article 56 in isolation. You got to interpret it in relation to Article 89. No,
Article 89 says
the Constitution should be.
What?
Go ahead, Mr. Sear.
Yeah, so I want us to lay the basis of the argument on Article 56. Article 56 of the Liberian Constitution grants the president the authority to appoint and dismiss public officials at will, without the need for cause. This provision ensures the president's unrestricted authority in governing the nation, specifically its states. All cabinet ministers, deputy and assistant cabinet ministers, ambassadors, ministers and councils, superintendents of counties, and other government officials, both military and civilian, appointed by the president pursuant to this constitution, shall hold their offices at the pleasure of the president. In essence, this means that public officials serve at the discretion of the president, and their tenure is not protected by fixed terms or specific conditions. But here is the catch. Hold on, gentlemen.
That's a
Here's the
conflict.
catch.
Yeah.
The law is clear there. But Anthony Jensen, law were created by the legislature that President Walker had agreed that this is within the rule of law, making exception. And the exception is by legislative power that receive the signature of the president that this exception will be abided by.
It's unconstitutional.
And it also spare out how anyone at the tenure position must be removed by cause.
Can I come in right there?
And yes, that's where you come in.
This is the issue. We that went to law school, even you from your civics teaching or whatever you learn from civics, these are the basic fundamental truth. The laws are in category. Category 1 is the organic law. There shall be no law in the land that shall supersede the voice of the framework of the Constitution. Statute created cannot conflict with the Constitution of Liberia. You have rightly read the voice of the framers. They said all officials And at that very close, at the end of that article, it says, "One, this constitution shall hold right? I mean, they should hold their offices at the pleasure of the president." When it says shall, it didn't say may, right? So anyone that is appointed at the level of cabinet or any official of government, this constitution, I do not know where this quote came from. I wish I would read their opinion, and I'm going to find it and read it.
Anthony, I have a question for you.
Yeah, ask the question, I will answer it.
Wouldn't you agree with me that when President Bouaka was vice president and these tenure laws were being created, it would have been more appropriate for him to have, or for their government to have set the tenure not to exceed the tenure of the president under whom one is appointed? Say, for instance, if you were appointed by WIA and once your tenure cannot exceed that presidency. I mean, that's one way I'm looking at it. Is that?
Yeah, I will answer this way.
Mm-hmm.
The interpretation of what we're reading is not for a specific president. I don't Joseph Bouaka, most of the policy and things he's doing right now, I don't like it. Right? And I feel that there are some things he's doing, overstepping his bound in some respect.
Mm-hmm.
But is it the way Liberians discuss issue is because if I'm not with CDC, anything CDC says that is right, I don't support that. If I'm not with Joseph Bouaka, anything Joseph Bouaka does, I'm not with him. Those kind of ugly attitude, I don't support that. The Constitution is speaking. We are reading it. You can read from that. It says what anyone that is appointed. Oh, they didn't say some.
So Anthony Johnson, you are saying in this case, due process is not required at all?
What do you mean due process? You can have due process. Due process is for the court to interpret. But can the court sit and hear a party that carry a case to court?
Action was taken by the president, and these people were kicked out of their position, and he said there was due process? Due process?
No. That's what I'm saying here. I'm not saying due process. Due process is to agree with the standing principle, the standing law in the case. Now, what we discuss is not a fight of the case. As I said again, let me repeat myself because no people listening. The Supreme Court opinion, I have not read it. But the fact of the case is, shall the president of Liberia appoint officials of government, or is there a tenure position where the president cannot dismiss an official of government? When the Constitution is speaking, if there's a statute speaking, the constitutional voice oversees the statute. So it doesn't matter when
the individuals were appointed by a president.
It doesn't matter. It doesn't matter. The reason why you have an election, the reason why you have an election is to turn over authority to the newly elected president. So all that happened during Joseph Weah time, if the wrong thing were done, Joseph Bouaka has the constitutional authority to do what the Constitution says.
Thank you.
Joseph Bouaka leaves today.
That is troublesome, Anthony.
Mr. Salib, you had a counter argument. Go ahead. I think
that is troublesome. What you are saying is going. What you are saying is going to set our country back.
But that's what I told you. This had no business creating that problem.
We would just be.
Let Salib go first.
We would just be like a country under. Yeah. What Anthony Jetson is saying is going to set our country into a problematic situation where we just be like a country swinging on a pendulum. We can't have one government come and set one thing and then another government come and negate that. Where are we going? The very thing we arguing, Joseph Bouaka was vice president. He signed off on it himself and the LA administration. Why didn't they just leave it? These were specific positions that they decided to make tenure. It was not all cabinet positions. These were specific positions, few of them, that they decided to make tenure. And you are the lawyer, and I'm saying law is based on intent. What was the intent of the earlier administration?
Law is also based on precedent.
I agree.
I'm coming from which JMB was vice president. What was the intent? There was an intent, maybe for continuum, for stability, and for other things. That's why they said, no, for these few positions, we want them to be tenure. That means whoever occupied this position, they will remain there unless they violate certain things. So if you come now and become president from vice president, who was the head of the Senate, you now become president.
And the president appointing power were not taken away.
They were not taken away. You still got the power to appoint, but we said for the intent of XYZ, we want these specific positions to be tenure. And you sign off on it. Now you become president, you say, no, I changed my mind. I can just fire these people. That is problematic, Anthony Jensen.
No, I think,
so?
and let me say
all right,
this
thank
on the
you.
word intent. Intent, those who are interpreting the law,
Yes,
the law is not based on intent. Intent is to find reason why somebody did something, right? Now, Joseph Boakai, let us assume Joseph Boakai was part of the Ellen government and the law was created.
he was not just part. He was the president of the Senate as vice president.
Listen. Being president of the Senate, the legislature, the current legislature and past legislators, there's no way that anyone who created law, the reason why people have law review, if there was any legislative action taken during the regime of Joseph Boakai when he was sitting as president of the Senate, if that law was wrong, it would be wrong forever. So it's just a matter of someone picking out the case.
Hello.
Yeah. So when I issue a speak up and it goes before an interpretative body, they make a decision. Now, for this identical issue, the Supreme Court want to put it to rest. So you and I should be talking. It has nothing to do with whether the country will be in chaos or not.
It won't be in chaos. You just answered. No. You just answered my point.
Time, gentlemen.
You answered my point. The reason you answered my point. So if he wanted to change that, he should have gone for the review. That hey, when I was vice president, we created this tenure position. I want us to review it so that we cancel it, so that I can make new appointment. You can't accept one thing in your administration. You come back and you cancel.
Anthony Jensen.
It's problematic. I don't know why.
Anthony Jensen, before I go to Jimmy here, so this was something from what you are saying was done illegally by creating turning positions, because your argument is
that's what he's saying.
It was wrong to have done so, right?
Of course, it was wrong.
What was done wrong? Why don't you correct it before you start making?
Before you start, that's what I'm saying.
Yes, right. Now you have a new, I think, the 54th legislature, this city. They have a right to review any statute that was created, right? But what we're doing now is the law is there; it has not been repealed. Those institutions that were created still exist. Now, a good government, a good country, when situations like this come about, either you guys who are sitting here debating the issue, and a group of citizens, or even the legislators themselves, they can say this law we have to repeal this law because it's conflicting with the Constitution of Liberia. For the Constitution itself, it cannot be played with like the way we do, the way we play football. It must be amended. The Constitution, like Article 50 says, if you want to create a tenure position, you should have amended Article 56 to say some cabinet officials or some officials of government will be appointed and removed by the president. But where you say all cabinet ministers, officials of government should be appointed, they should work at the will and pleasure. They shall work at the will and pleasure of the president, not me. You cannot take a power away from the president.
So if it has not yet been repealed, and then you violate it, is that not a problem?
It's not a violation. That's what I'm arguing for, that this Constitution is the law. So it means that Joseph Boakai is not in violation of what has happened. But let me say this.
I don't know where we go with the conversation, because the Supreme Court has spoken. So where is this conversation going?
What are we talking about? The
Are you a lawyer?
Has not been repealed.
No, when the Supreme Court speaks and you got a contrary opinion, you read an article.
I'm not reading an article.
I'm speaking an article. But for now, the Supreme Court has spoken. That is the law. L-A-W, law.
Gentlemen, let's do something. Let's do something.
The Constitution of Liberia, the Supreme Court opinion, different laws.
For the
Supreme Court is the most important.
Hello, gentlemen. Hello, please. Hold on,
yes.
You and lawyers say Supreme Court is the most important.
Most important. I tell you that for sure. Most important, because
the highest court in the land.
The Supreme Court is a preacher of the Constitution of Liberia. No doubt.
Let me tell you why I say so.
No. Don't even
go, gentlemen. Let me bring Jerome in here. Jerome, so we're talking about rule of law here. And if this government feels that what was done was wrong, or now it's wrong, what do you think should be the approach? By appointing people to a turning position, or by undoing the law so that you can follow what is the rule of law? This is the rule of law of government. What's your take? You are muted, Jerome. You are still muted.
I want to give Anthony Jensen a break. because he said he has not read the decision by the Supreme Court. So he's talking, he's flying. He's not actually, he has not absorbed, he has not read. So he's actually guessing here. Because he and I, even though we all didn't go to law school, we know that the Supreme Court of any country is the final arbiter of the law. We know this. There is no argument here. Whatever the Supreme Court says, you got people there who are esteemed lawyers. They have interpreted, they have argued among themselves, and they came to a 4-1 conclusion that this decision was wrong by the president was wrong, and that settles this thing. Now, I think Kwame Clement made a case against Joseph Boakai. He said, for those of you who are looking at one particular article in the Constitution, you are wrong, because the Constitution was never written to be interpreted in isolation. So now here we are, and we agree. My disappointment, though, is with my bastard brother, Councilor Jewett, to actually disgrace and bring our Supreme Court and our judicial system to disrepute. When he said that the entire Supreme Court was appointed by a president, we are therefore, whatever they have done is predicated on partisanship. My friend, this is scary. That one man, or from the leader, a man who is, I think this is a man that practiced before the bar, the Supreme Court of Liberia, to say that the Liberian Supreme Court is basically a political party, that these people are not clothed with the integrity of being on, not even on the Supreme Court, but being lawyer, much less Supreme Court at the highest level. And most of those people that were appointed were not all citizens. I think
to be attacking Jewel why he's not here is not proper. Let's deal with the issue. The issue that should be discussed. Jewel is where you respond.
No interruption, please. No interruption, please.
Jewel sent his opinion. It was read here. I think maybe you were not here. Mr. C is going to reread it to us. But he believes that their decision was purely political as opposed to judicial. And to me, anybody who is a foreigner from a foreign country listening to a man who was licensed to preach before the bar, saying the bar is useless, is concerning. That's all I'm going to say.
This is the quotation of Kwame Clement. Let me read it for you quickly. He said,
Kwame Clement article shouldn't be the basis of
no, but it's part of
no interruption.
He said any interpretation. He said any interpretation of Article 56 that says the president has the power to remove at his pleasure the tenure heads of these agencies because they are other government officials will render irrelevant the plain language of Article 89 and violate the rule that one provision of the Constitution should not be interpreted to defeat another provision or render it meaningless, which is true. So what are we arguing here? If you wanted to appoint these people and dismiss those tenure positions, the first thing you would have done was to repeal that part that created this tenure position. Before you do that, but if we are saying every president that comes to power can undo precedents at will, then we are setting our country up for conflict.
More than that.
More
than that. The part of the ruling that I have read so far, they did not say the president was in error or in violation. They said there are procedural errors that he made. I don't think they're taking away his power of appointment. He just did not go about it the right way. I think that's the argument here.
There was an overstep and it was an overreach.
These people were
not
with that.
But just a point, there are two aspects to legality. There is a substantive law and there is a procedural law. And it takes a combination of all two to make legality. So if you get a substantive law correct and you miss the procedure, you are operating illegally.
Sure.
If you get the procedure and you miss the substantive law, you are operating illegally. You know? And the other thing is this issue about will and pleasure. Let's correct it. Only political people, because the judge is appointed by the president but does not serve at the pleasure of the president. Imagine what will happen in a country when judges start serving at the pleasure of the president. Anybody who sits in an adjudicatory capacity does not serve at the pleasure of the president. For example, if you are at the PPCC and there is a problem with procurement, give me an example, give me a break, because there is something we need to clarify legally.
Yes.
Not everybody in the government they serve at the will and pleasure. We need to correct that.
The Constitution corrected
When
itself.
you sit in the adjudicatory capacity, you do not serve at the pleasure of the president.
Please.
I can point to point now, moderator.
No, I'm giving examples of people who have tenure and they are sitting in adjudicatory capacity. So they don't serve at the pleasure of the president, even though the president appointed them. I'm giving an example with the PPCC, for example. You have two parties arguing over procurement, and the people who are sitting at the PPCC have to make a ruling. They cannot serve at the pleasure of the president. So that is the underlying legal logic of this tenure thing, and why some people may be having executive position, but they enjoy tenure. So to suggest or interpret pleasure of the president in the Constitution as a blanket thing and that across all officials that are appointed is just plain wrong, because it's not true.
You're getting it wrong.
Yes, my question. Anthony Justin, yes,
can I to a point, Mr.
Anthony Justin, yeah, it's my question. If you are arguing President Bouaka is right to have acted the way he did by appointing people to tenure position, why up to now he has not appointed people to the National Election Commission? What is stopping him?
That's a very good question, right? And I said from the onset of my argument or my position was that not everything that Bouaka is doing I'm happy with. But let me set this record straight with Freeman and then go to the Brotherhood depending on Kwame Clement, because you guys want to rely on name Kwame Clement. Let me deal with that issue first. The Constitution, Article 89 says the legislature shall enact laws for the governance of these commissions, meaning the Civil Service Commission, the Election Commission, and General Auditing Commission. These are the three creatures of the Constitution that say the legislature shall enact laws for the governance of this commission and create other agencies as may be necessary for the effective operation of government. Now, for the purposes of the argument and for those who listen to us, the legislative power is not being in dispute. Nobody's arguing with legislative power. But when the legislators are creating law, they should not create any, like the Constitution says, all cabinet ministers should work at the will and pleasure of the president. The legislature cannot create a civil service agency or commission, election commission, and the General Auditing Commission and attribute tenure position to them, because the Constitution is already clear that all officials of government should work at the will and pleasure of the president. So if you are legislators, you're creating a piece of law which is given to you by this Article 89. Kwame Clement argument is faulty. All right, I want you to listen to me. Because
allow me to come in there.
Hold on, gentlemen. Do officials say the National Election Commission that you quoted that the Constitution established, right? Do they say have the will and pleasure of the president?
That's a good question, right? So then, if I'm hanging on Article 56A of the Constitution that says all officials of government, aren't the election commissioners officials of government? Are they not? That's the question I'm asking.
My question is simple. Though at the National Election Commission, do they serve at the will and pleasure of the president?
They should serve at the will and pleasure of the president as per Article 56A.
Okay.
But I want to insert something here. I hear Attorney Freeman argument very well, and he argues that having educative powers renders you not subject to the will and pleasure of the president. But I want to insert here that even you can have these educative powers, but it doesn't necessarily render you exempt, especially in systems where the executive branch has dominance over appointments and removals. That is the check to that adjudicative power. Now, had they done it in the judiciary, that would have been one thing. But when you come in the executive, where the chief executive has power over all, that adjudicative power is put in check by the executive power.
And this is where I'm not understanding the president. Hold on, gentlemen. This is where I'm not understanding the president. The president appointing power is not being restricted with the creation of turning position. All other turning positions that were created, the president appoint. That power has not been taken away. Now, you talk about will and pleasure. I disagree with Anthony or Jason that National Election Commission bosses are serving at the will and pleasure of the president. But that he's saying that the president can tell the National Election Commission, but you know what, that election result announce this person. If you don't do it,
no. You're taking
that's why you're accurate.
That's why it is.
So what are you talking about?
Don't be
These
sentimental
people
here.
are insulated from political influences.
And that's a reason why.
They are insulated from political influences. The president appoints to remove them, even the National Election Commission boss, you know better than me, it should be by cause. If the president get out today, well, I fired National Election Commission. So let's say why election process is going on. There will be an issue. It's the same with all other turning positions. The president appointing power has not been taken away. They are saying for the president to remove the person, there must be a cause. What's your disagreement?
My disagreement is let all of us be reminded here that we do not speak because we desire something. The Constitution, even the Supreme Court judges, oh my God, the Supreme Court judges, their interpretation should be textual, should be historical, and when they are doing these things, they do it for the general good of governance, right? The Constitution has spoken, other people understand the language over there. For Anthony Freeman, let me just deal with that quickly. The judges, the issue of judges, the Supreme Court, the Constitution itself dealt with the judges. So they do not fall under Article 56 as to removal or appointing officials. The president can appoint them, but the Constitution says judges should live. The only way you can remove judges is for them to be impeached. That's why the Constitution says clearly. So the issue of removal does not apply to judges, right? The Freeman addressed that issue. The issue of I think paramount chief or obviously there are some positions that are given in the Constitution, 10 positions are given them. So if the Fremons wanted to allow the election commission to be created with a tenure position, the civil service agency to be created with a tenure position, and the general auditing commission, they would have said it. But if a statute is created and there's a constitution that is standing, which one do we look up to?
But actually, doesn't the very constitution give the legislature the power to create all other laws?
Yes.
But I think that's relitigating the issue. This is complete relitigation.
I understand what you. I want to ask Attorney Jensen a question. I agree. Me and you are on the same basis here, but why has the Supreme Court continuously ruled against removing the tenure personnel? Why?
That's a good question. That's a good question, right? And I will be in your mind the same way. Why the Supreme Court is not reading Article 56, and that's what I said. I don't want to be blindly. I would respectfully disagree with the Supreme Court. Let me be clear on that. Because I know there are some individuals who going to back when they shouldn't be backing. Let me respectfully disagree with the Supreme Court if they disagree with Article 56A that says the president has all right to appoint and remove officials of government. If the law is that, there is no ambiguity in that provision of the Constitution. So if the court is in disagreement with that, I would want to read the voice of the court.
Right.
To compare that with what the Constitution is saying. But like I said, I haven't read the opinion. And I'm not regularly condemning the Supreme Court for what they said. They have all right to do what they have done. But
another aspect of the Supreme Court ruling.
Yeah, but let me just land. The reason why I asked Attorney Jensen, the reason why I asked that question to you, because by ruling several times against it, they are setting precedents and thereby making a law.
No. You get it wrong too. Precedents are not law. Precedent.
But how are laws? Laws are formed by peace-students.
Counselor, why are you talking on the show? I mean, why are you talking on the show? No, you can't say anything you want to say on the show.
You say precedent is not law. Listen to my opinion.
No, you can't say anything you want to say, Counselor.
You can't listen to any other me.
No, Counselor, you can't say anything.
At Focus on Liberia, we discuss everything Liberia, from education to politics, arts and culture, entertainment, agriculture, history, religion, family, and technology. Focus on Liberia uncovers and showcases the best of Liberia and shows the world the truth about Liberia. We educate, elevate, and promote all things Liberia. We conduct interviews, panel discussions, debates, and more. Tune in to Focus on Liberia on Facebook and YouTube and be a part of the stories that make up the news.
This is Focus on Liberia, and I am Tenured.
And I am Anthony Sied. Of course, this is Focus on Liberia. We are on our program Between the Headlines. The topic for today, the Supreme Court ruling on tenure position. The Supreme Court came down with rulings on several tenure positions that have been contested. President Bouaka nominated individuals to various institutions that are tenure, and those individuals occupying those positions pray for a writ of prohibition because they felt that President Bouaka was in violation. They have tenure, and the president was removing them and appointing other individuals. They believe the president was in error because tenure, in their opinion, is constitutional. And they went to the Supreme Court, and the Supreme Court said, hey, you are right. But there's one that didn't succeed or that survived, if I can put it that way. The EPA boss, that your Emmanuel Ure Yakwawo case was different.
There's a reason for that.
And that is the one that we are coming
There's
to
a
now.
reason for that. I can step right in. The reason for that.
And I'll bring
Eastman, let him lay the premise. Let me land. No, there's something that I don't want to be misinterpreted. This is
At Focus on Liberia, we discuss everything Liberia, from education to politics, arts and culture, entertainment, agriculture, history, religion, family, and technology. Focus on Liberia uncovers and showcases the best of Liberia.
Gentlemen, I know we are all
I was in
spirited
speech,
about this
Mr.
discussion.
Moderator. You're not being fair to me. I was in speech when you went off. So we come back
Anthony Jensen, I will not have you do that. I'm not being fair to you. You are speaking more than all of the panelists here.
No, I can't make people on. But there's a question that was asked, and there's a conflict in that. Why can
but I don't want
Anthony Jensen, we dealt with that. We move to another thing.
No,
we can't
when the
solve every
lawyer
problem
is saying
here.
precedent is not
The
law.
discussion here is
But then that's the
time,
issue. So you listen to me. You heard him saying it.
No,
I
no,
know you
I'm
cannot
just
say
saying.
Precedent is not law.
All right.
How will you say precedent is
guys,
not law?
let Mr. Sied lay the premise.
At Focus on Liberia, we discuss everything Liberia, from education to politics, arts and culture, entertainment, agriculture, history, religion, family, and technology. Focus on Liberia uncovers and showcases the best of Liberia and shows the world the truth about Liberia. We educate, elevate.
Of course, God gave us this country. This is why we are debating, and the debate is spirited, and I can understand that. But gentlemen, let us exercise patience. Allow me to moderate. It's sometimes difficult to control mature people. Gentlemen, the Supreme Court is saying the case between Emmanuel Ure Yakwawo who was appointed to the EPA after Winston Tapper prayed for a writ of prohibition. The Supreme Court ruling is that Winston Tapper appointment was in error, that the law or the act creating the EPA was not followed by the president of Liberia, President George Manawia, when Winston Tapper was appointed. And so for that reason, Winston Tapper did not win the case. The law says that there is a board that must be constituted, and that board must nominate 3 individuals to the president of Liberia, from whom the president will appoint one person to be the head of the EPA. That was not done according to the Supreme Court. And because of that, Winston Tapper cannot maintain his position at tenure, and he didn't get a turning position because his appointment was in error. That is why we want to discuss now. Gentlemen, again, I ask the question, does the Supreme Court have a point here? If so, we have Emmanuel Ure Yakpawolo also serving at that position that the president now sent him there. Is the president of today not in error, just as President Weah was in error, as stated by the Supreme Court? Jimmy, you go first.
Yeah, thank you very much. From what I understand with that, with Professor Tapper's ruling, he, because the legal procedures were not followed, he was merely acting in that position. So by right, he doesn't have no rights to it because he was only in an acting position. But from the other thing we said, judicial decisions create legal precedents that subsequent courts often follow in deciding cases. This principle is known as stare decisis. So that the Councilor Jensen, I want him to. This is known. He said no. It doesn't have a precedent. But here it is. There's a principle known as stare decisis. When higher courts make rulings, the lower courts will follow, because those are the precedents they have set, and that is a principle in law. So I would like him to answer that. Why he say it's not, it does not apply in this case.
And before Anthony Jensen can come in, I want to get your clear position on Winston Tapper was acting, Waka let him go and put someone there. The person he put there, I'm not sure if the board is constituted yet. So Ure is acting. Is it fair now to say Ure too is not turning? He's just acting as Tapper was acting. Is that what this is?
I think the way around that is to make them officer in charge. So I think that's the way around that. But you do have a point. Yabawolo's presence there is not a full-fledged, should I say, commissioner, but he's an officer in charge. I think this is what happens when there is that vacuum until that vacuum is removed.
So the whole officer in charge thing, is it not an appointment? Because the position is an appointed position by law. To be in a position that requires or that can be filled by appointment, one must be appointed. Let me learn. One must be appointed to occupy that position by executing the functions of a position that requires appointment. One must be appointed by law. Isn't that what it is? And if he is acting as not appointed to an appointed position, is that not a violation of the law? I'm just curious.
I think it's simple, and the Supreme Court has already interpreted that. We have similar problem here in the U.S. President Donald Trump, most of the cabinet ministers he appointed, they just were all in acting role. Why? You can do the appointment, yes, but the appointment says the procedure you have to go through Senate confirmation. Until Senate confirm you, you don't have that authority. You are just an acting. So the Supreme Court has already litigated that. They already come up with their ruling. When it was Winston Tapper, they did not follow the procedure that the board had to sit and do XYZ. So until you get that board back in, then you are just acting. So if that's what this other new person appointed by Bwaka is doing also, then the same laws that apply to Wilson Tapper also applies to him. They say, listen, we have to follow procedure. We have to follow laid down rules. Joseph Boakai, Joseph Biden is having the same problem. When Louis DeJoy took over the U.S. Postal Service, yes, they also had the same rules that they got all these other governors that have to agree and vote upon this person who's nominated by the president. So Joseph Boakai, even though he's the president, the post office head, Louis DeJoy, he cannot be fired by Joseph Biden. He must do it. He has to go through. That's why Joe Biden has not been able to touch him. So when we come to Liberia, we can't just be overstepping one law to another law, because when the Supreme Court rules in our favor, then it's a good ruling. When the Supreme Court does not rule in our favor, then, oh no, it's not a good ruling. It should be repealed. We can't keep doing this. So let's go by what the Supreme Court has ruled in the Wilson Tapper case and apply that to every other person who's appointed to that position. If the board does not say they do not confirm you, then you just act it. It's the same thing. You get an appointment, you do not go through Senate confirmation. It's just an appointment. You got to go through the process. It's simple, ABC.
Anthony Johnson.
Okay. When we went to law school, we were taught some basic facts, where you get a fact given you. When your fact is given you, you raise the question. When the question is raised, the next thing you do, you find the law. And the very first law that any lawyer, any good lawyer will look for first is the Constitution of Liberia. When the Constitution speaks, you can boast about your presentation in the courtroom. If the Constitution does not speak as to addressing the question that is asked, you look up to the statute created by the legislature. If that doesn't work, then you go looking for other regulations or precedent cases and all of those stuff. You can't say, I am not saying you can use precedent, but when you have the Constitution speaking and somebody want to rely on precedent, that's a problem, right? So all I'm saying here, and I'm saying it because as a lawyer, I'm answerable to what I say. I've said it clearly that precedent cannot be a matter. What we're discussing here, you all have read Article 56, what it says. Someone talking about precedent. Supreme Court can, all of these cases, Supreme Court is coming, there could be a future Supreme Court that could overturn those cases.
You just negated your own discourse, because in your beginning you said when a question is raised, a good lawyer, the first thing you do, you go to the Constitution. When the Constitution does not speak, then you go to
the statute.
The statute. So then why go to the statute? Just forget about the statute, because that's why you keep.
But I mean, you don't understand. Even when you are putting me right here, but you don't understand.
You said no.
I think we're there with that aspect of the discussion.
You said precedent is not law. Is that not what you said?
No, you don't understand. You don't understand. You don't understand.
No, you said precedent is not law. You want to deny that?
You don't understand what I said. That's what I wanted. That's what I told. That's what I told the moderator from the onset. I don't want you leaving the forum and misquoting me.
You said precedent was not law, and you're the lawyer. You should educate us. And you tell me
I have told you the category of laws that we rely on, right? So if it is not the Supreme Court, if it is not the Constitution of Liberia,
the Supreme Court is the highest court in the land.
Mr. Salim, you made your point. Give him a chance to speak.
When we are all confused and the Supreme Court speaks, that should be the final. But you are telling us that we should not listen to the Supreme Court. We should not listen to the president. You said it.
No, he didn't say that. He said he disagreed with the Supreme Court.
No. He said precedent is not law. And somebody put it in the group chat that precedent was law. He said that. And we can't people listening to the show.
Mr. Salif, thank you. Mr. Salif, thank you. Your point is made. Anthony Johnson, can you conclude on that? And my question I asked is... Yeah, my question I asked was that, hey, here is a ruling against Wilson Tapper because the law will not follow according to the Supreme Court. Now, President Boakai also got Emmanuel Ure in that position. And I'm of the belief that because this is an appointed position, for one to execute the functions of that role, that one must be appointed. What is your take?
I will go back to just what the Constitution says. The president has the right to appoint anybody to any position in Liberia to occupy those positions or a position. Now, the issue of Ure, I don't like to discuss issues where I don't have the facts. If Ure has been appointed by Joseph Boakai, and the position require presidential senatorial confirmation, that person must go through confirmation before the person can act pending confirmation. That's a right given. So if Uri was appointed and has not been confirmed, that's an issue in itself. But
In
what I'm
that
understanding,
case, focus on liberal political analyst, J. Victor Namwe said he's acting in that role. Is it legal that he was sent to that place to act when it's an appointed position? You think it's legal?
was he not? He was appointed by the president to act, right?
Yeah.
The president sent him there. I don't know whether that
Right.
was
So
appointment
if the
or
president
not.
appointed him to act, now the question would be: is he not within the confirmation of what the Constitution is saying? If he is a head of government, an official of that agency, then he should have gone through the confirmation process. Who's supposed to
I
raise
know,
the issue?
I know you disagree with tenure position, but the act creating the EPA said for somebody to play the role of an executive director of the EPA, that one must be nominated by the board of the EPA. The board is yet to be constituted. The board is yet to nominate 3% to the president for the
I see
president.
where you're coming from, and this is my final comment, guys. I'm supposed to rush somewhere. This is my final comment on that. If the statute creating that agency call for a nomination by the board for the head, then that statute itself is in error. Because the Constitution that voice we were reading says all officials of government shall be appointed by the president. So if the legislators went and created that institution and attributed the president power to the board, that is illegal. That is wrong.
That act did not take away the power of the president to appoint. And mind you now, the very Constitution mandates the legislature to create all other laws.
Yeah,
and the legislature now has created this law. Let me learn. The legislature has created this
law. Not to take
law.
away the presidential power, not to take away the
No, it did not take away the power of the president.
That's what it did. If they give it to the board, if they give it to the board, that's taking it away from the president.
The board does not appoint. The board
Actually, I don't understand where we're going with this
I don't understand where this counselor is going.
Guys,
exercise patience because people are following the discussion. They are complaining that there's no more interruption. Please,
before the councillor leave, one question before he leaves.
Okay.
The president appoints ministers in his government. And according to our laws, these ministers also have to go through the process of nomination and confirmation.
Confirmation.
Are they taking away, according to Jensen now, the logic here, let's follow the logic.
Wow.
By the ministers going to the Senate for confirmation, according to him, they are taking away the appointment, the appointment power of the president, because once the president appoints you, nobody else has any other reason to question you. And that is absolutely wrong, Mr.
It's completely ludicrous.
Are you asking me a question or you just concluding?
No, I'm going to tell you, I'm not asking you a question, I'm telling you what I know.
Okay, this is why there are two words that Liberian can miss already.
I'm not done. I'm not done.
Let her touch.
The president have just done most of his cabinet appointment, and they have to go through the process of being vetted by the Senate and confirmed before they can take office. Are you telling me because they are going before the Senate, that means they are usurping and denying his constitutional power?
And the Senate has the right to reject those appointees.
Well, let him answer now. Let him answer.
This is my answer to you,
gentlemen. Please, people are.
This is my answer to you, and this is my final comment, gentlemen. I would have loved to be here, right? But this is my answer to you. You are in fact mixing the word appointment. There is always nomination. The Constitution says the president shall nominate, and the Senate shall confirm. Right? After the Senate confirms, before the president commission or appoints. Appointment is the last stage in the process for an official to take office. Now, Liberia always makes this thing up. The president always nominates to the Senate confirms, and after confirmation comes appointment. In some cases, before commission, in the case of those military people, right? So the issue of appointment is of no issue as to what we're discussing on the constitutional voice. The constitutional voice says the president shall appoint. That appointment is after all the procedural steps.
Mr. Jensen, before you leave,
But that's what the Supreme Court is saying,
but
Anthony,
listen to
that
this.
there are
Listen,
procedures that are
If
laid
there's
down.
one thing that the Supreme Court has been very, very consistent. When you go to the decision that was made in the asset recovery case.
Gentlemen, please, I'm late. I'm getting late now. Sorry for
all right.
Please, it was a pleasure meeting with all of you guys.
Thank you.
Okay.
Yeah.
Okay. One thing that is consistent, the Supreme Court have been consistent. When the asset recovery thing came, the Supreme Court said it was a procedural error. Go back to status quo ante and do the right thing by the procedure. It's the same thing here. The Supreme Court is saying, Mr. President, you have the right to do everything else, but you need to go back to the procedure. In the case of Wilson Tapper, it's the same thing. The Supreme Court has been very consistent. Mr. President, where you did not follow the procedure in nominating and confirming this man, so therefore he's not protected by the tenure law. So go back. So the Supreme Court has been very consistent when it comes to the procedure. So for you to say the Constitution negates the procedure because the president has absolute power, I think Mr. Jensen is wrong here. Thank you very much.
And let's look at it from this way, sorry, Mr. Sear. All these procedures are just set to help the president make the right decisions. That's all. So when it comes to the EPA, say let the board sit, and the board will vet somebody amongst them and forward that name to the president. The president appointment power is not taken away. It's the same way with superintendent. The legislative caucus in every county, they sit down, they vet people, and then they send that name to the president. The president makes the appointment. It's just to help the president make the job easier on himself because he doesn't personally know everybody. So you need the help of the board to make that recommendation to you. You just get up, you say, no, there is no board. The board has not been appointed. The board has not sat. I will just appoint somebody. And we are, the Supreme Court is saying, listen, let's follow this procedure. And the counselor is saying, no, the country needs no procedure. The country needs nothing, no precedent, nothing. Let the president just do. Then we can just go into a kingdom, the kingdom of the Republic of Liberia, and just make Joseph Boakai the king, and he can just do anything on his own.
And this is why I said what is being done here is tantamount to a hostile takeover. This president knows that he cannot remove people who are tenured. He also knows that when the board is not constituted, he cannot appoint people there. And that's why he appointed officers in charge. But he decides, and I think he chooses to remove these people who are tenured. And I think it was just it was a direct confrontation with these people, which I think was really unnecessary. He knew exactly what was at stake here. And I think he decided he was going to go ahead anyway, because why? He is the president of the Republic.
But you know, I don't really believe that is him. I think there's a political issue behind it. There's a force that's pushing it.
It is the president that makes the decision.
Yeah, but I think no. But we've been seeing a point where nominations and withdrawal. I mean, different people are pulling strings here.
The Constitution grants him a privilege to do so. So if people are doing it on his behalf, it's on him. So you
more
can
than
say,
that, Anthony, more than that, even if the president, even if the nominations were done unbeknownst to the president, now that these cases have become high profile, they would have caught his attention. So we can't say that these for this full position just kind of slipped away. The people went to court. He knew all of that, and he had the opportunity to course correct. I think he just chose not to.
I'm thinking that he party pushed him to do it.
And Jimmy, my question for you is, and I'll come to Anthony Freeman here. My question has not been answered here. Maybe I'm not paying attention. Emmanuel Ure, is he acting? Was he appointed? Was he put in charge? Is it legal to have somebody serve in an appointed position? Because the process or the requirement to fill a position that requires appointment is for one to be appointed or nominated. Is it legal for somebody to act? That's what I want to know. Jimmy?
Yeah, you know, that's the crisis we find ourselves in. Because technically, I mean, right now I can just say he's only an officer in charge until that whole process is followed legally. So that's all we can say. He's again just acting.
And being in charge and acting is not in contravention of the act, creating that particular position or that law, because the law is clear. Hey, for someone to serve in this role, there must be a board constituted.
But in the case where you don't have
be
nobody, if you don't have nobody there yet, somebody has to act. That's not going to contradict it.
I want to agree, but I want to know, is that legal? And that brings me to Anthony Freeman. Anthony Freeman, this whole thing about officer in charge, is it legal?
Yeah, the president can appoint people in acting capacity.
Okay.
But I don't understand why this president will have.
What is the law that supports that backs that?
What to appoint people to act in acting capacity?
Mm-hmm.
Yes, for administrative or executive branch official, he can appoint people to act. But substantively, if he's going to appoint people substantively, they have to follow the law of that particular institution. So if you go to the ruling, because I think I sent a ruling to you earlier.
Yeah, but before we get to that, right? In most of the ministry, this is what I see. The president now, for administrative reasons, will say, well, the most senior civil service employee at this agency can act. But in this case, with EPA, Emmanuel Uwe Yakbawo, my friend, was taken out side of the government structure, meaning being appointed from outside to go and act. Why couldn't the president say, well, there are people in there, maybe the most senior civil servant that should act? Why take somebody from outside? Is that legal?
Look, I don't know the details of that. Okay? It's not like I know the details of that. What I'm saying to you is that in the Supreme Court ruling, the Supreme Court mentioned that there should have been a meeting of the Policy Council, and the Policy Council should have been involved in the appointment and approval of the executive director. And the fact that Professor Tappe or procedure of getting to the top at EPA did not follow that procedure, so the tenure protection did not cover him. So I think what is more important in that is that in order for the current president to move forward with the spectrum of legality, he has to follow the procedure laid down by the Supreme Court. I think that is the most important takeaway from this ruling. And it's very important because there's a lot of agencies out there that have boards, and the president just usurps the functions of the board and go ahead and appoint people without consultation to the board. And because sometimes people don't want to be in conflict with the president, sometimes they just allow it to pass. But the Supreme Court is giving some of the boards the authority to reject some of these things and call for the president to follow the rule of law.
But Councillor Freeman, that there is another question subsequent to this. So if, for instance, Dr. Yapolo cannot be seated, or because he couldn't be seated, what about those under him who were also appointed, like Alari Toba? I think he was one of the commissioners. Do those people then wait for the ruling from the Supreme Court? I was done today. I'm sorry?
Alari Toba, I think that good governance that they sent him.
Oh, okay. All right. I'm mixing up. But anyway, my point is, if the head, right, is being challenged, what does that do to the subordinates? Do they also have to wait for a judgment? Because I think even at the Good Governance Commission or Yelu, whatever his name is, I'm not sure if he has gone to court, but he was being accused of politicking, but he's saying that he wasn't given due process. So I believe he's also challenging his removal. So my question is, if he were to, let's assume he would do that, what does that do to the other appointees underneath him?
Well, legally, if the Supreme Court issues such a declaration, it obviously means it covers the subordinate officials. Okay. But back to Anthony's point, I want to read just a section of the EPA law.
Okay.
The section that covers the appointment of the executive director. Can I go ahead?
Yeah, please do.
Okay, so I'm reading from Part 3. Organization and administration of the agency, Section 16. Part 3, Section 16, title as the executive director. there shall be an executive director who is a person with wide environmental knowledge recognized, common to sustainable management of the environment, appointed by the president from a list of 3 names recommended by the council, and that's the policy council, except that the president may appoint an interim executive director pending the formation of the council. So the Supreme Court is redirecting. The Supreme Court is redirecting Mr. Bwaka that before you appoint, and which is very shocking for Bwaka, 50 years experience, that before you appoint, you must read the law establishing the institution. Read the law, read it. Before you appoint, take the law of that institution and read it. How can somebody have 50 years of experience and not read the law before making an appointment? So the Supreme Court, that's why they're telling him, next time, Mr. President, before you appoint anywhere, take the law and read it. Because it's written in plain English for everybody to follow.
And he has lawyers, legal counsels to read the law, right?
That's what I mean. He has the Minister of Justice, he has the legal advisor, he has political advisor, he has a whole bunch of people, so there's no reason for you to make these kind of rookie mistakes. And we were told that he has 50 years of experience in governance.
Thank you, Anthony.
50 years experience. That's a good. What you just read might have answered the question that I've been asking concerning Emmanuel Ure Yakpawulo, because from your reading, it said that in the absence of the board being constituted, the president can appoint an interim executive director. So in Tape's case, the board was not constituted, or the governing council was not constituted. So President Weah appointed Tape as an interim. My question now is, when an interim is appointed, that interim person does not enjoy tenure?
No.
The appointment is not consummated.
That's why the Supreme Court just said you do not have the protection of a properly constituted person. Now, the reason, one of the things that I'm worried about here is, when we were growing up, we heard, or in our circle, we heard people like, what a young man named from the Justice that used to work with Bishop, what did you?
Bishop Michael Francis?
Yeah, where the gentleman now who is now legal advisor or security advisor. The Kofi Woods of the world, who were advocates for constitutional law and judicial practice and advocates for everything that was right with the law. Where are they now when our constitution has been trampled upon? Where is our own man, our own son, our own brother from FOL? We are talking about what a girl named Brown, the guy who was from FIU. Alice Coffey. These are people who are on our show here saying they were experts in the rule of law and governance and management. These are people that we produce from our show here. Where are they when the Constitution is upside down? Where is the Imam Krayi? These are people who say they were the moral fabric. What happened to Dr. Reeves from the Providence Baptist Church that were running for president, the advocates of law? What happened to all of these people?
Mr. Goodman, I think
they are counting on the experience of the president, and maybe the person is doing a good job.
Mr. Goodman, I think the whole thing is just a mere power grab, okay? Because all these agencies, apart from the Constitution, they have their own individual procedures that they follow. So my question is, what was the hurry in President Bwaka? If the council has to be appointed and instituted and sitting to make recommendation on 3 names on which the president can appoint, why don't we start from that point? Why not fix the board? Why not do this? Look at this young man in Senegal, Faye, with no experience in serious governance apart from the tax area that he worked. In the matter of a month, he has appointed all his cabinet ministers with no noise. And we have somebody who's been in government all his life, and they just having these missteps, and nobody wants us to say we should correct them. We say, oh no, everything now, a lawyer will tell you only the Constitution speaks. No precedent speaks, no procedure speaks, nothing. So the president has absolute authority. When the EPA charter is saying to appoint EPA boss, the board, the council must be instituted. The council must make recommendation to the president. It's so simple. Why can't we just follow it? Why just
no?
jump?
But there's a simple reason.
Mr. Salih, Mr. Salih, you use that tough language here that this is just a pure or man paragraph. By the
paragraph.
Yes, my question. Don't you think the president was also testing the law?
Why test the law that you were once upholding when you were vice president? Why test it?
Maybe he had a disagreement, and at the time he couldn't voice it out.
Why? He was the head of the
remain silent.
He was the head of the Senate.
You have the right to remain silent.
No, listen.
Anything you say will be used against you in the court of law.
He was the head of the Senate, and he had the power.
Maintained his silence, and now he said, "Well, I'm going to act and test this thing in the court of law." Don't you think that's what the president is doing here?
He was the head of the Senate. He had a tie-breaking vote. So if wherever the Senate voted and there was a tie, he had the power to break that tie. So that was a serious rule. So you can't say you were silent at that time when you had a tie-breaking power vote, and then you wait, you enjoy it, then you come back now, you want to mess everything up. Listen, we got to call it out.
In all fairness, the former vice president was silent. And I know Mr. Gilman knows the code. He said, look, I was parked.
Okay,
so
I agree.
Was silent. And there's a question I have for you, J. Victor Namwe. Your progressive brother, Wilson Tapper, when he came out of the courtroom, the journalist asked him, the journalist said, hey, Professor Tapper, the Supreme Court have made a decision that really didn't favor you. What's your take? He said, look, this is all we all advocated for.
Wilson not progressive?
What do you mean?
Wilson not progressive?
But listen, man, let it
Wilson not progressive. I won't correct it. Wilson not progressive.
Okay,
we're here. Let you finish the question.
No, Wilson has been with us. Man,
you were way before your time, man.
Jimmy, and you can maintain your disagreement. That's fine. But I am of the opinion that Wilson has been a progressive brother. So he said, wait, the Supreme Court has decided this is what we pray for. And he went by saying, hey, I could bring talks to do against them, but that would not be proper. That's not me. The Supreme Court speaks, and that's final. That is the rule of law. Well, are you impressed with what he said? Or is it just a matter that he had no other option and he just tried to second?
I think it's a little bit of both. I think Wilson he knew he had finally hit the wall. I know unless someone said, I think he was just testing the waters, testing the law, but I think he knew that he couldn't go anywhere beyond the Supreme Court. I don't think Wilson would do otherwise also. He's a stand-up guy. I was even a little bit surprised that he actually went as far as going to court on this matter, because I think he should have known from the get-go that this case was not going to go his way. But however, we're always allowed to test the law. So I think he tested the legal system. But yes, I think he realized that he had reached his end, and he had nowhere else to go.
Thank you, Anthony Freeman.
Yeah.
Go ahead.
No, well, I mean, you want me to comment on something?
Are you reading something else?
No, you want me to comment on Wilson type of issue?
Yeah, I want you to comment.
Yeah, he did.
Oh man, except to say, look, when the Supreme Court rules on an issue, they set a precedent. That precedent is law. Unless that precedent is overturned, then the new when the precedent is overturned, the new law now is the new precedent. So at all point in time, the precedent is the law, and it remains the law until it is overturned. So right now, what it means is, look, Mr. President, you have the appointing power. But there are a lot of institutions that have specific laws, specific statute. Before you appoint, read it. If you don't understand it, call your legal advisor, call your minister of justice, call anybody and try to find out what the law says. But you know, it's so embarrassing that when you are president and you take certain action and people tell you it is wrong. And even on the show, we said it repeatedly that there is just no way that they would have won this case. And now they go to the Supreme Court and the Supreme Court told them, no, you are wrong. So what's the point? Why have waste everybody's time? You have spent the past 2-3 months discussing something that is very obvious, because there was no way after 3 prior rulings in favor of constitutionality of tenure position that the Supreme Court was going to recall the tenure position. So they just wanted to go to court. Yeah, test the law. Now they got it. Now maybe they can concentrate on something else.
Here in the U.S., before the U.S. president make an appointment, he consults his legal scholars. They check behind every law surrounding that appointment, so they know it, the statutes on the books, the procedure from that particular agency, everything, they check it before they even take any step forward. I don't see how President Bouakai would just, I mean, I think he has wrong advisors. Maybe he's not listening to his advisors. Maybe he's just doing things on his own. But this is a failure, and the rescue train got to stop, recalibrate, and start to do some things over.
Thank you. Mr. Gilman?
Yes.
Are you still a progressive? Or you were the CDC, right?
Oh,
CDC can be progressive too.
Of course we are.
Okay.
They
for all the way, were you with the UPP, right?
Still with the UPP. That's correct.
Still with the UPP, but singing the CDC song. Go ahead.
That's right. You know, as in the United States, when George Bush appointed Bolton to be our ambassador to the UN, he was denied. He went for confirmation. He was denied, and the president appointed him anyway because he had that power. But the statute that gave him that power says he can only serve in that position for 1 year, and he has to be re-nominated or reappointed, and he can only do that twice, and then he has to drop. So Bolton was never formally confirmed as U.S. ambassador to the UN. I want to believe, since we follow the track of the U.S. Constitution, it's the same thing. So my brother or our mentor, Tape, should have known, if he has served in that position more than 1 year or twice, he should have known that he did not have the protection of tenureship. He should have known that. But I'm glad, as an educated or progressive, a man who believes in the rule of law, he went to the Supreme Court. The Supreme Court ruled. He didn't do what the lawyer just did to say, I disagree with this Supreme Court. The Supreme Court is I mean, if the Supreme Court, according to Jewett and Jensen, the Supreme Court was a partisanship Supreme Court, Tape is a sedition. And if they are sedition, why did they rule in his favor?
That's true.
So that debunks Mr. Jensen and Jawed. I mean, it's embarrassing what these people come out here and say on our show, and they don't want you to take them to task. For you to say, because these people appointed these people, so they will negate the law of the Republic of Liberia, they will leave it aside and just pick up the PAPD. Our pro agenda book and start using it as a text in the Supreme Court. It's ridiculous.
No, actually, that comment really put the Supreme Court in disrepute.
Of course, I just said
it's not a kind of comment you want to make about your country. Besides that, Wilson is a graduate of Louis Arthur Graham School of Law.
Of course,
he knows what he's doing. And if he had a case like that, it didn't rule in his favor. But if there was no way he could win because the procedure had not been followed. It was very evident, so there was nothing he could do about it, but to say the people are sedition, that is a wrong statement to make.
It's wrong. Thank you, gentlemen. We will now go to the phone line to take some calls. Let's take some calls here quickly. And folks in, internet land who are following and you want to participate, the number to call. The number is posted in the Facebook and YouTube live feed below. And let me read the number for you. It's right here, 605-313-6004. and you have to enter the code 791-403 to join the conversation. We have some callers. Let me bring our first caller here. The man Livingstone Flomo is live. Your take. You have a minute.
Thank you, Mr. C. I'm very sure. I'm doing sitting listening. Look, for me, people say, "Oh, the president lost." It's not a loss. We all read it. The Supreme Court ruling. The Supreme Court did not say the president and the executive cannot go back and remove those people. It just said you have to follow the procedure. If you read it, the court said they didn't give the reason why these guys were being removed. And I'm glad the president appointed the ombudsman who will be in charge to do that. And the code of conduct, I hope he had it, but I put it up there so the people can read it. It said a tenure position and appointed, leader for the president cannot campaign or campaign in the election. And we saw videos of people like that doing that. So the president has that power, that's the force that they can use to remove them. And I'm a little bit afraid that people on the show, a lawyer, Attorney Freeman, and all saying that the Supreme Court, why they said the precedent, it is the law. So we should just get rid of the Constitution and just go by whatever the Supreme Court said. We just go with it. And I'm preaching the Supreme Court said, we should just follow it. And then
it's not the only source. It's not the only source.
Jimmy, please don't interrupt the caller. You will have time to respond to them. Go ahead, Mr. Livingstone. You are protected.
So I'm a little bit afraid if Anthony Freeman will be representing like bro. I'm kind of concerned if they're making such a statement like that. That Supreme Court we shouldn't respect the Constitution. We should just go by whatever the Supreme Court said.
Thank you.
For me, the president did the right thing. I'm glad he tested the law, and it's not a loss. It's not a win. That's why the president appointed the ombudsman, which will revisit those cases if they broke the law by, be participating in the election, which caused the removal. We'll still remove them. I can tell you before the end of this year, it will be removed.
Thank you. Did you speak to the president? You're speaking as though you people are on the same page here. You said by the end of the year, they will be removed by cause.
They will be removed by cause, but because the president has appointed an ombudsman, which previous administration were not able to do that, but at least the president has the courage to
Are you suggesting the appointment of the ombudsman is to go after these people and remove them for cause?
to investigate if those institutions broke any law. So if they broke any law, for example, the code of conduct clearly said that you cannot campaign. If you have a training position, you cannot campaign in the election for any political party. You should be neutral.
Okay.
And the code of conduct, if you are caught doing that, you should be removed. That's breaking the law, and we all should respect the law. So that's the law on the board, so we should respect that.
I agree with that 100%. I agree with that 100%. They must be removed by cause, and that has been my position as an individual. They must be removed by cause, not the way it was done. We have Mr. Thomas Cannon is on the line. He's a practitioner here at Focus on Liberia. You are live. You have a minute.
Yeah, quickly, good show. Anthony, Councillor Freeman read the EPA Act, but yet he was saying that the president did not read the Act. The other ones for which the Supreme Court said the procedure will not follow, I think that is by the law. But I think what the president did in the case of the EPA, you cannot say they did not read the law, because the last sentence you read said that except that the president may appoint an interim executive director pending the formation of the council. And Dr. Ure was appointed in an acting capacity.
That is correct.
Since President Weah did not form a council over his 6 years. So I think in this case, you read it rightly, but then, like said, the president should read, he has 50 years. I agree with you, but in this case, I think the president was right. So, and then the council was formed on the 11th of April when the EPA Policy Council was appointed. So I think what the president will have to do in this case is bill for the council to now nominate 3 persons to him. It might include or might not include Councilor or Dr. Lewis, and then the procedure can be followed. But I think in this case, the president followed the right procedure. The other thing I wanted to state quickly and I agree with him on is that in some instances, these boards that are established as governance institutions, in some instances, they are not even put in place. And one I will quickly reference is the board of the Liberian Revenue Authority. For 6 years when President William was president, he never fully constituted the board of the LRA. The way the board of the LRA is constituted is that the chairman of the board must be a civil society or private sector representative. They have 7 members. The 2 are one civil society, private sector, or they should be non-governmental. And those 2 non-governmental persons should serve as the chair of the board. And then you have the finance ministry, justice ministry, and then government agencies constituting the remaining portion. But President William for 6 years never appointed a non-governmental representative. And so the co-chair on the board, which is I think the justice ministry, became the chair of the board for 6 years. So I just wanted to highlight that on the issue of these boards, whatever president is in place needs to make sure that they are in place because they are part of our governance structure. But on the issue of the EPA, I think Anthony Freeman got it wrong. He read it rightly, but interpreted it the other way around. Thank you.
Thank you. We have another caller. That is the man, Evis Morris. Evis, how come you're not the first caller today? Mr. Morris, you are live. Go ahead.
Flomo beat him to it.
Evan Morris.
Sorry, I was muted.
Okay, go ahead. And please raise your voice a little bit.
Yeah, thank you. And hello to the panelists. I want to say I enjoyed, Attorney Freeman's show today. I think his point was well taken. The president, President Boyka, everything that he said, not everything that he said, but what he said during the campaign and what he was going to implement is going against it. And I think we all see it right now. And like many people say on the show, if you have the legal advisors, any decision you want to make, you have to consult with these guys. That's why you bring the brightest minds around you and you get the best legal advice from them. Uji Ben Keita, and other legal people around the president should have advised him on how to proceed. And I'm no lawyer, but we understand, Attorney Freeman said, if the law is on your side, you argue the process. And that was a prime example of what happened against, in the topic. The progress was not on his side, so he lost the case. So in this situation, the process and the law is not on President Boyka's side. So right now, I don't think he's done anything wrong. Like everybody said, lawyer will tell you, always test the law. The deciding factor will be what he does after this. If he insists on doing it again, or following what the court said, and then taking these people to court for cause, and then let the court decide if the cause is justified, and then you can remove them and replace them. So, this is a beautiful thing to see in our country. We see the process working out, and we're here for it, and we're thankful we're alive to see some semblance of civilized law taking place in our country. So we're all looking forward to how the entire process will play out. But good analysis. I disagree with Attorney Jensen on some of his cases point, but again, it's all in spirit of the debate. But we appreciate it. Mr. Gilman, please invite Attorney Freeman for our show on Sunday. We have to be on the panel. But thank you.
All right, thank you. And he will be our last caller. Gentlemen, time is fast spent. Respond to a caller of your choice in 30 seconds, and in another 30 seconds, you give your closing. Who wants to go first? Jimmy, you want to go first?
Yeah, I'd like to go.
Wait a minute, you came late and then you're going first?
Mm-hmm. So you get me out of the way. I'm going to sidetrack. Since you came after me, I'm going to sidetrack. As far as I'm concerned, progressives were more socialistic in their thinking. And this was, I grew up with these guys. Okay, we talked every day. We had debates, just like how we're having debates now. And the only thing I always said, I'm not going to label myself, but I'm going to make any kind of reform that is necessary for the country. And that's why when you see Wilson was a progressive, no, Wilson always been on the capitalist side from the time I've been doing, and I know that guy from high school, very fast, very sharp guy. And so I'm kind of surprised. But back to the case in question, there are things that we need to straighten out. I think this is just the tip of the iceberg. There's some deep issues with our Constitution. It happened with the citizenship, and there's also other causes that are very conflicting. I think we need to have a review on the Constitution, because if you don't have that organic, as you lawyers put it, if you don't have a clear, a living, document that will keep the country together, it is potential chaos. So I think we need to review it, have some constitutional conventions, have some referendums or initiatives, see some executive and legislative action so we can make it right. We can't just sit down idly and not and think it's just going to work itself out. We need to study it. That's all I got.
Thank you. Mr. Salif, you're closing.
Thank you. I think I want to react to the last caller who talked about, President Bouaka was trying to test the law. It's highly frivolous to me, because I don't see how a president will be elected to office and say, you know what, I think I got to test the law. No, he didn't know what he was doing. And that is a shame. After how many years in government, he didn't know. He didn't sit down and advise himself that, hey, I want to test the law. It was a complete overreach, and it was power grab. They should have sat down and look at things carefully before taking some of the steps they took, and then they wouldn't have been embarrassed at the Supreme Court as they did. My closing would be, hey, we came to rescue. So whatever the previous administration did that was wrong, then we got to be careful to do it right, because you can't say you're coming to rescue and then you keep repeating the missteps of the past. Then that's going to be questionable. So I think they still have time. It's 6 years. They still got lots of time, and they should try to course correct some of these errors they find themselves in.
Thank you. The Focus on Labrador political analyst, you're closing.
Even though Mr. Kamara doesn't accept that, but listen, I think for a long time, a number of us have been asking when the judiciary will stiffen the spine, grow its spine, and I think this is one of those days when we should all be proud of the judiciary standing up to the executive. I think Pastor Shirley continuing to remind us that this was an attempt this was an overreach, power grab. And so the fact that the judiciary told the press, gave the president his marching orders and told him to go back, and get it fixed, and he can come back. But at least he knows now that he has to do it and do it right. So I think we should all be very proud of the judicial system today. I think it's a good day in Liberia. It is unfortunate for the executive. This is like someone said again, this is a rookie error. This is something that was really avoidable, and they could have corrected it, and they just dug their heels in. And I'm glad that it turned out the way it did. I don't think they should go and pointing accusing fingers and all of that. Just go back, get it right, and if you want to come back, you come back. So I think, thank you also. It was a great show for the opportunity. Thank you very much. Glad to be here.
Mr. Goodman?
Great. Thank you very much, guys. Councilor Freeman, Attorney Freeman, thank you very much. Political analyst, you're on point. Mr. Eastmore, great show. Mr. Salif, awesome. Always come back. I want to respond to Mr. Flomo Livingstone, who says he knows exactly what's going on. They are going to come back and go after these people because they saw them on video. They were campaigning. But then this is where they're going to lose. And I'm telling him now, because the United States Supreme Court has ruled on this, that the right of a person to articulate their opinions and ideas without interference or retaliation from government. We are talking about campaigning is free speech. Spending money is free speech. Sending your money, no matter how big it is, they may have limit. Spending, they say capitalism, they say capital, they say money. The U.S. Supreme Court has rule on this. Not because I'm running or I'm in government, so I do not forfeit my right to free speech. Campaigning, choosing that I'm a Republican, announcing it and voting for the president, it is not in violation of anything. You can say I violated a rule by going to a court and say you did X, Y, Z, but to say we are going to go after them because we saw them, like Mr. Aliu Kamara said yesterday, we saw them wearing T-shirt with Joe, we are signed on this, so that is signed for dismissal. Those are what we call witch hunt. Yesterday, the campaign that was going on in Nimba, the entire Unity Party, the entire government was there. I mean, you name it. What a young man named Mo Ali. Everybody was in Nimba County yesterday, live. So if you are going to go after these people, you want a job because you say you saw them in photos or in video campaigning for George Weah, that is a cause for removal. We are headed down to a slippery slope that nobody will be able to survive. And this is not a way to run government. Thank you.
Anthony Freeman, get a last word for tonight.
Okay, thank you very much. Just briefly to Mr. Kane, he raised an issue. When I read the EPA law, I wasn't saying that Bwaka violated the EPA law. I was only reaffirming the Supreme Court decision. The Supreme Court had made a decision. I accept that decision. I think it was correct. I think Bwaka was correct in the EPA law. But he was wrong in other areas. And I'm saying as a general way to proceed, Bwaka and his advisor must sit down and read the law of the institution before appointing. Very simple. The other thing I want to say is when the president is unsure of what to do, get his legal people to write him a legal opinion. Because when they write that legal opinion, they will survey precedent by the Supreme Court, and all of that will be in the legal opinion. So by the time they advise him with that legal opinion, there is no way he is going to make the kind of rookie mistake that he's making. I mean, he suffered 2 legal defeats in 90 days. That is unprecedented, you know? So eventually, what I want to clarify, the last thing I want to say is that not every official in the government appointed serve at the will and pleasure of the president. We need to get that straight. Even if you are in an executive agency, when your tax require you to write laws, or we call them regulation, and your tax require you to interpret laws, most likely those type of officials don't serve at the will and pleasure of the president. And you mentioned a very good example like NEC. And there's so many examples of people in the executive that do not serve at the pleasure of the president. If they were to serve at the pleasure of the president, the entire Liberia will be in chaos. So people need to know that there is limit on the president power, and not everybody who is appointed necessarily serve at his pleasure. And it's good that the Supreme Court has not set a new precedent, because I assume it was done in three cases before this one, and this is the 4th case in which the Supreme Court is saying, reiterating that the legislature has the right to limit the presidency, the appointing power of the president. So we need to accept that it is down the law of the land and move on to something else. So I'll stop on that note.
Thank you, gentlemen. Great spirited debate, and I think our audience got something. This is how we'll come to the end of tonight's edition of our program, Between the Headlines. The song "We Are All Liberians" closes the broadcast right now. Thank you, and bye-bye, everybody.
Have a good...
Liberia is our home. Liberia people, Liberia.